Hi, Daniel.
Hi, Francesca. Look, last time we spoke with Dan Scott, we just heard that the Court of Appeal was going to hear the leapfrog appeal in Arkin and Marshall on the now not so new Possession Practice Direction, PG51Z. The appeal's been heard and judgment was handed down just last week, so I thought this would be a good opportunity to have a catch-up on some of the more interesting points arising from the judgment.
Absolutely. So we've got the judgment, and in substance, it addresses three issues pertaining to the legality of the practice direction, and it then addresses whether the court has a general jurisdiction to lift the stay. But in short, the practice direction is very much here to stay, and the court rejected the appeal on all grounds. Daniel, do you want to kick off by taking us through the first legality challenge?
Yeah, sure. So the first limb of the legality challenge related to the question of whether the practice direction was validly made under Rule 51.2 as a pilot scheme. Now, what Rule 51.2 tells us is that the key test for determining whether something is a pilot scheme is the question of whether it's aimed at assessing the use of new practices and procedures. So there's got to be some element of a trial run or a test to see if this is something that's going to be kept. Now, the Court of Appeal held that the practice direction was in fact doing precisely this. They said it was assessing whether blanket stays of this kind were an effective way of achieving three very legitimate goals. The first was relieving pressure on the justice system during a time of crisis. The second was protecting court users and court staff. And the third was reducing the risk of the spread of the virus that might be occasioned by the enforcement of possession orders.
So the practice direction, or a version of it, might continue past its current end date.
That certainly seems to be something that's suggested in the judgment. So the Lord Chancellor actually intervened at quite a late stage in the case, and he made the submission that the Master of the Rolls may, he didn't say whether he would, but may, on the back of this practice direction, seek to introduce a permanent rule imposing similar stays, either for the duration of this crisis or perhaps even for future crises as well. Now, it's unclear whether that would be confined to possession proceedings or have broader applicability, but it does suggest, as you say, that these stays may have life beyond the current end date.
And the prospect of further stays is relevant to the second issue, and that was whether the practice direction was inconsistent with or rendered unlawful by the Coronavirus Act 2020. And in that respect, the analysis focused on Schedule 29, Section 2 of the Act, which, in relation to proceedings against statutory tenants, increased the notice requirement to 3 months. But it also gave landlords a right to apply to the court to dispense with this notice requirement if the court considered it just and equitable to do so. So the appellant argued that the practice direction rendered that right futile, as any application or proceedings would be immediately stayed. The Court of Appeal found that there was no conflict between the practice direction and the Act. And in this regard, they placed particular significance on the fact that the Coronavirus Act lasts for 2 years, if not longer, whereas the practice direction stay only lasts for 90 days. So what's quite interesting is that the Court of Appeal have recognised that there could be a permanent rule or practice direction that imposes a limited stay on possession proceedings further down the line. And so therefore, depending on the nature and duration of that more permanent stay, this question of conflict may have to be revisited, as in theory at least, a longer stay could create a situation in which some of the rights created by the Coronavirus Act are rendered meaningless for a sustained period of time and therefore are in conflict with the practice direction or with a new iteration of it.
That's absolutely right, I think. And of course, it also leads to the question of whether a longer stay would be compatible with Article 6, which was the third ground of the legality challenge. And in particular, whether the practice direction is compliant with the test set out in Lord Reed's speech in the Unison decision.
Oh, yes, the Employment Tribunal's case on court fees.
That's right. And what Unison tells us is that any measure which impedes or frustrates access to the courts must have a reasonable justification and must go no further than is reasonably necessary to fulfill the objective in question. Now, in Arkin, the Court of Appeal said, in what is admittedly quite a terse paragraph considering the range of factors in play, that they were satisfied that the measures here were justified and that the brevity of the delay meant that this was not actually effectively denying access to justice. And while there might be debate to be had there, what's interesting looking forwards is if there is a possibility of the practice direction being extended, then plainly there must be a tipping point, and there might be risk of that tipping point being breached, where the delay in the parties being able to vindicate their rights before the courts becomes overly intrusive. So it's something to keep an eye on. But of course, Arkin was never meant to be a constitutional challenge. It was actually a private law case where the appellants were just concerned that the stay had torpedoed their agreed directions and wanted some clarity on the practicalities around the stay. Do you want to say a little more about that, Francesca?
Absolutely. So that practical point came up in relation to the general issue as to whether the court has jurisdiction to lift the stay imposed by the practice direction. So the Court of Appeal was asked two questions in this regard. And the first question was whether the amended practice direction could be construed to mean that any case management directions agreed between the parties should be carried into effect, notwithstanding the stay. The second question was whether the court has this general discretion to lift it. But looking at the first question then, the Court of Appeal found that as a matter of construction, the amendment to the practice direction is clear, and its effect is to allow the court to embody directions agreed between the parties in an order, but to do nothing more. The appellant submitted that it would be an empty right if the agreed directions remain subject to the stay, i.e., what is the point of case management directions if neither party is required to comply, and if one party fails to comply, the other party has no immediate ability to require compliance? But the Court of Appeal said no and raised 2 points in response to this.
Well, presumably there is some, albeit perhaps very small, value to having the directions at least agreed, so it's not an entirely empty right, it seems to me.
Absolutely, and that was their first point, that there is an inherent value, as you say, in having a timetable in place for when the stay is lifted. But their second point was a little more interesting, and in this regard, they said that the parties could agree and get the court to endorse directions to take place during the stay, and the parties could then voluntarily get on with those agreed directions, albeit the court recognised that they could not enforce those directions during the stay. But this goes against the general rule that no steps whatsoever should be taken during a stay, which is also borne out of the commentary in the White Book of paragraph 3.1.8, which cites the 2018 Court of Appeal case Grant and Dawn Mead. So in that case, the Court of Appeal found that, in general terms, no steps in the action by either side are required or permitted during the period of the stay. So we've gone from the Court of Appeal saying no steps are required or even permitted to steps may in fact be voluntarily taken during a stay.
But what might the cost consequences be if a party takes steps during the stay?
Absolutely. So the cost consequences are quite unclear. The general principle is that a stay does not necessarily mean that costs incurred are not recoverable. So the starting point is that goes against recovery, but it will depend on whether the steps taken were unreasonably or prematurely taken or incurred. So parties with proceedings afoot or those who want to agree directions during the stay to get proceedings moving must be cautious, because although the Court of Appeal has endorsed parties voluntarily taking steps during the stay, the parties must nonetheless be mindful that any costs incurred could subsequently be scrutinised by the other party, or indeed the court, as to their timeliness and reasonability, and potentially therefore be irrecoverable. Typically or ordinarily, the safest route might be to ensure the costs were recoverable, would be to apply to court for an order lifting the stay. But it seems that that's not really a viable option here, though, is it?
Well, not quite, no. So the court did in fact hold that the practice direction didn't operate to oust the court's general case management powers. So theoretically, a judge would have jurisdiction to disapply the stay in a particular case. But the court was, of course, quite concerned to circumscribe the exercise of those powers, so said they had to be informed by the presence of the practice direction, and in fact went as far as to say that it would be, and I quote, almost always wrong in principle to exercise the jurisdiction to lift the stay, save in the most exceptional of cases. That, of course, begs the question of what circumstances will be exceptional, but the court basically suggested that only where the operation of the practice direction was frustrating its own purpose of protecting public health might it be appropriate to do so. One such case might be the University College Hospital case that we mentioned last time, but in the majority of cases, I think it's safe to assume that's basically going to be a non-starter.
Yeah, it seems really that the clear message from the Court of Appeal is that though there is discretion, courts should really not be using it to lift the stay.
Of course, we do know from the UCH case as well that injunctions are still available, and beyond that, parties may also think about other possible remedies, declaratory relief, maybe trying to seek a money judgment, and I understand that Ben Faulkner might do a further video on those arguments.
In that case, we better watch this space.
Absolutely. In the meantime, good to see you, Francesca.
Really nice to see you. Bye.